For nearly 2 decades, the Belgian tax system has been locked in a relentless tug-of-war over a single question: what exactly counts as creative work? And more importantly, how should it be taxed? In 2008, the government recognized that traditional artists and writers often face highly unpredictable incomes. To protect them, lawmakers carved out a special tax shelter specifically for revenue generated from copyrights. Instead of standard income, taxed at up to 50%, copyright earnings were taxed at a flat 15%. This gap turned a niche protection into a mainstream strategy for IT consultants and designers whose daily output met the legal requirements. By throwing a lifeline to struggling artists, the state had built a powerful financial magnet. Within a few years, thousands of Belgian companies had restructured their payrolls to utilize this specific tax classification. By the end of 2022, the government decided the system had moved too far from its original intent. Lawmakers drafted a sweeping program act to pull the system back. The new rules introduced strict revenue caps and a much narrower definition of who qualified for the favorable rate. The new legislation struck the tech industry directly. The law explicitly excluded software programs and their developers from the copyright regime starting in 2023. The fallout was immediate. Many tech workers saw a sudden drop in their net pay, while employers scrambled to find ways to increase gross salaries without ballooning their payroll costs. The rush to close the loophole effectively removed the tech sector's primary financial incentive, leaving developers and employers to navigate the standard tax brackets they had avoided for over a decade. For the next 2 years, the excluded sectors pushed back. Tech professionals argued that under existing economic law, computer code was already legally defined as a literary work protected by copyright. Following the 2024 elections, political momentum shifted. Lawmakers began to concede that treating software code differently than a traditional manuscript was a legal contradiction. This led to a new project of law in 2025. The tax code was updated, and software programs were explicitly readmitted into the 15% copyright framework. Architects and structural designers were also brought back into the fold, joining tech professionals in the eligible category. This reversal ended the legal distinction that had fractured the creative economy, restoring the previous tax status for digital creators. The pivot acknowledged a simple legal reality, that in the eyes of the tax office, lines of code and architectural blueprints now carry the same legal weight as any other protected work. However, this victory came with a serious catch. The return to the system in 2026 does not mean a return to the unchecked mechanics of 2026.
To understand why, we have to look at the flat rate expense deduction. Historically, creators could automatically deduct a large percentage of their copyright income as expenses before any taxes were applied, pushing their effective tax rate well below 15%. But a parallel 2026 Program Act changed the rules. Today, that automatic flat rate deduction is completely off-limits to anyone who does not hold a government-issued artswork certificate. For IT workers and architects, the reality is stark. They are allowed back into the 15% tax bracket, but without those automatic expense deductions, the final financial benefit is significantly lower. The state ultimately rebalanced the system by changing its tactics. Instead of fighting over who qualifies as a creator, they restricted how those creators calculate their taxable base. After 18 years of wild swings, the regime has finally settled somewhere in the middle. It remains broad in its definitions, welcoming digital professionals, but strict in its financial execution. The saga proves that while defining creative work is a matter of law, deciding how to tax it is a matter of persistent legislative negotiation. This video is for educational and informational purposes only. This is legal information, not professional legal or tax advice.